I'm here with Saul Weisenberg, who is the head of the white-collar department of the Washington, D.C. law firm of Nelson Mullins. Saul, thanks for being with me today.
Great to be here.
Now, you're up here in part, you were on a panel discussion earlier dealing with the discussion of the so-called predator state and the role that the state plays. And the question was, how does the state foster innovation if it is itself captured by predatory capitalist interests? And of course, you look at it from a different perspective because you often are defending the so-called bad guys. And I'm just wondering what your perspective on this whole issue was.
Well, I've had the benefit of experience on both sides.
Yeah.
I was with the Department of Justice for 12 years. I was head of the bank fraud division in the Western District of Texas when we were prosecuting savings and loan fraud. And I've been on the defense side for 15 years. What we were really talking about this morning is why has there been such a dereliction of duty by the Department of Justice in their investigation and prosecution of the bank fraud crisis, the mortgage meltdown crisis that
in contrast to the savings and loan crisis when you were involved in those prosecutions, as was Bill Black. And what is the answer to that? Why is that the case?
Well, different people have different perspectives. I think that it's a combination of lack of resources, incompetence, and a political decision at the highest levels not to seriously investigate this. And I think there was general agreement that the third reason, the political decision at the highest level, was what was going on. Now, why that is, you probably have a lot of different views.
Well, I mean, one of the views is that I think Lanny Breuer himself suggested that you can't possibly prosecute these guys because you will get a recurrence of Great Depression 2, and that there'll be a meltdown of the global financial system.
Well, that's completely ridiculous because you don't have to worry about. That's an argument you can make when you're deciding whether or not to prosecute the institution, but that's completely irrelevant when you're deciding whether or not to prosecute the officers, the corrupt officers of an institution. That has no effect on the economy whatsoever, except a good deterrent effect to keep people in similar situations from doing that in the future.
Because in anyone who is a champion of free markets, whether you take that perspective from the left or the right, it seems to me that the rule of law must be a fundamental prerequisite to having a proper functioning market economy.
I agree, and for whatever reason, this administration does not seem to want to prosecute people or even investigate people who seem to be obviously flouting the law. It's not only in the financial crimes arena. We've seen it in other areas too, and I can't really explain it. It's remarkable. You have never had this kind of a dereliction of duty in the 20th century by the Department of Justice in prosecuting or investigating financial crimes. I made the point that, look, you don't want to prosecute people just to send a message if they in fact are innocent. There might be lots of substantive reasons why you wouldn't actually, in the end, indict somebody who you think is involved in the criminally involved in the financial crisis. Just to take one example, it could be somebody who gave full disclosure, may have been in fine print, but who gave full disclosure in the financial instruments that he and his company were peddling out in the market. That would be a very tough hurdle to pass if you're trying to indict a person like that. Department of Justice is only supposed to prosecute if they think there's a reasonable probability that an impartial jury will convict. So there are valid reasons, but there's really never a valid reason to not investigate what appears to be such massive wrongdoing.
And that's really the issue. I mean, as you say, the threshold is: are we likely to secure a conviction, and therefore should we go ahead and prosecute? But it went beyond that. There was a question as to whether you even want to investigate, check the loan files, for example, in these mortgage cases, and there just doesn't seem to have been any attempt to even look for the existence of any possible prima facie evidence of fraud, for example.
Well, you know, in the very interview you quote, the famous Lanny Breuer interview on 60 Minutes, they mentioned a particular institution, which I'm not going to mention, and he said, we investigated and we found no wrongdoing. And in the same episode of 60 Minutes, they talked to the chief compliance officer of that institution who had been forced out, and she said, no one ever interviewed me. So they didn't interview her. By definition, the investigation was either non-existent or completely incompetent.
Now, as you say, we could easily prosecute miscreants. We don't have to prosecute companies. But in fact, since the decision of Citizens United, there is an argument that corporations are actually people. So why not extend some of these laws which we use to prosecute felons to companies? Because in fact, now the Supreme Court has said that a company is a person.
Well, they said that a long time ago, actually. It's very easily, as a legal matter, it's very easy to prosecute and indict a corporation. We saw that with the recent prosecution of SAC. The standard is quite low to convict a corporation. And if any of its officers, essentially, I'm simplifying a little bit, but if any employee or officer is acting within the course of his or her duty, and even a part of his motive is to benefit the corporation is guilty. And in the SAC case, for example, 5 or 6 people had already pled guilty. So, I mean, that was an absolute laydown. The company had no defense. So that's really not the issue. It's easy to win against corporations. It's what is the effect on the economy. And the prosecution of Arthur Andersen, the conviction of Arthur Andersen, which, as you know, was thrown out by the Supreme Court in a decision that almost everybody realizes was the right decision in that particular case, and yet the company was gone and dead, and it had an effect on a lot of people. It had an effect on the economy. So I think it's a legitimate question. I don't think you never prosecute a corporation. If a corporation has shown over a period of years that its management is corrupt, if senior management in 3 or 4 different eras have been found to have committed crimes, I think there is an argument, an equitable argument for going ahead and pulling the trigger. But it's never because it's hard to prosecute corporations. It's easy.
The Sarbanes-Oxley area is another point where you would think that you could have had some convictions. One would think that some of the evidence has come out about bank executives consciously discouraging regulators or restricting the flow of information to regulators would seem to, and then signing off on accounts would seem to fly in the face of the Sarbanes-Oxley legislation, and yet we've seen no prosecutions under that act either.
Well, you don't even need Sarbanes-Oxley. Look, wire fraud and mail fraud have been illegal in the United States for about 100 years. So that's really not the issue. Sarbanes-Oxley made a couple of things easier. But really, if you're committing fraud, if you are deceiving somebody in order to obtain money, and you're using the wires or you're using the mails, that's a fraud. So to take the example I hear about most from the most recent financial crisis, if you are representing, when you're selling a pool of residential-backed mortgages, and you are warranting to the purchaser that they are sound, that you've done proper auditing, and that all the mortgages underlying the pool are sound, and you know, or somebody in your organization knows that that is false, that is something that is if you can prove it, that's a crime. And we've had a number of SEC suits based on that, and we've had private class action suits based on that, and people are settling. The institutions are settling rather than fighting. So don't tell me that that's not something that shouldn't be investigated, and that if proven against an individual, forget about the company for a minute. Just you'll have a great deterrent effect if you prosecute the people that did that.
Except that in many instances, you're getting these large settlements, or they seem large in financial terms, but in fact they provide broad sweeping immunity. In many of these mortgage cases, for example, you have class action suits settled by Bank of America, J.P. Morgan Chase, Countrywide, etc.
Well, I don't know what you mean by providing immunity. They can't provide criminal immunity. No private litigant, not even the SEC, can guarantee that kind of immunity. The only one who can do that is DOJ. Now, DOJ has done a couple of those non-prosecution agreements, some of them in astounding circumstances, but they're the only ones that can do that.
The DOJ did that in the case of HSBC, I think in Standard Chartered, that there was actually evidence of criminal conduct and the sorts of things that were allegedly funding money laundering trafficking and allegedly providing assistance to terrorists, the sort of people that we're supposed to be going after. And yet, as Bill Black pointed out, there was no criminal prosecutions. We just had a big settlement. They wrote a check, and that seems to have been the end of it.
Well, what was interesting about that was another example. That was another instance where Mr. Brewer was asked specifically about that, and he said it would be too damaging to the economy. But again, that's only the case, that's only an argument that can be made, and that's for people at a higher pay level than me, about in a particular instance, what will the effect be on the economy? What will the effect be on innocent workers? But that says nothing about the individuals involved. Corporations only act through their agents. So if you have a corporation, and let's not restrict it to that institution, because in fact, this has happened quite a lot in this Justice Department. A corporation can only act through a person, and if a corporation enters into a deferred prosecution agreement with the Department of Justice and admits, as part of that, admits we did all these things that were criminal, then your next question is, okay, well, what people did that? People have to do that. And we see shockingly few instances where there are follow-up prosecutions against major corporate officers. You'll sometimes have middle management people thrown overboard. That's a favorite thing to do. But it's very rare that you see, even after these agreements where there's no longer an allegation, the company is admitting we did this, you see very few individual prosecutions. Quite stunning.
I was thinking not too long ago about someone like Jeff Skilling, the former CEO of Enron. He's still in jail. I mean, he's had a reduced term, but he was put in jail, as was his CFO, Andrew Fastow, for devising these special purpose vehicles, which effectively masked earnings, and it was considered to be a form of financial fraud. Chuck Prince at Citibank got a $70 million pension payout. His company was noted for creating these so-called special investment vehicles, SIVs. And it seems to me that there's not fundamentally much difference between the SPVs of Enron and the SIVs that were embraced by companies like Citicorp. They were used, in a sense, to misrepresent earnings.
I can't speak to that. I don't know enough about the special investment vehicles. But I do know that if you are doing something, if you are an entity and you are creating a vehicle and the regulators know about it and it's openly done and the people on the other side of the transaction know about it, I don't think that is a crime. I don't even think that's necessarily a regulatory violation. So everything depends upon the circumstance. And if you're doing something that everybody in the industry is doing and it's known and examiners know about it and don't do anything about it, I may have a problem from a policy perspective, but I don't think you should start waving the bloody shirt and say those people have to be indicted. So even if it might look functionally the same, it may in fact not be the same. And the theory, there are a lot of people who think the Enron prosecutions were improper. The theory behind Enron was that this stuff was hidden. And that's always a key. You know, disclosure, who knows about it?
Since, is there anything about Dodd-Frank which you think has improved the environment for financial regulation and indeed prosecution of some of these situations that you've described?
It's too early to tell on the regulatory side. It's too early to tell. On the criminal side, it won't make much of a difference. Sarbanes-Oxley didn't make much of a difference. You know, the criminal provisions of Sarbanes-Oxley have not been used that much. The criminal provisions have always been there. Federal criminal law has been interpreted very broadly, it's at least since the 1950s, since the Warren Court. Prosecutors have enormous power, and that was used to full extent during the savings and loan prosecutions. So the statutes, you don't need to have this debate about regulation or too little or too much, or the Canadian system versus the US system. The laws are in place, the fraud laws are in place to prosecute wrongdoing if you commit the resources to investigate and do it.
And do you think that we're likely to start seeing the resources committed towards this area in the future?
Not in this administration, you're not. I mean, that's quite clear. I mean, and like I said, it goes beyond the financial. I mean, look at the robo-signing. Example is just that's financial, but that's that's another example of it. Those are lay-down cases. Those aren't hard cases. Everybody knows what happened. People have gone into court and admitted, yeah, I lied. I perjured myself about whether or not I'd read the underlying documents, about whether or not they'd been signed, and yet there've been virtually no federal prosecutions. Now, you've got a Democratic administration. You've got falsehoods that are made in court in order to throw people out of their houses, middle-class people out of their houses, and none of that is being prosecuted. That's just stunning. That's unprecedented.
And it may not change until 2016, and even then, there's no guarantee, because even if we get another Democrat, if he or she follows the same kinds of policies.
You know, one of the great ironies is that, generally speaking, in the last 50 years, Republicans, when Republicans have been in control of the Department of Justice, they've done a much better job and a more aggressive job of prosecuting fraud than Democrats. It's not because they're more ethical. I've got a theory about it. And the theory is that they're identified in the public mind as so close with big business that whenever there's a big scandal, they feel like we better prosecute.
It's a bit like the Nixon goes to China phenomenon.
Exactly.
Yeah.
But for whatever reason, it's a real difference. And I mean, remember who was president when the savings and loan crisis hit? It was the end of President Reagan's term when that crisis first hit. But then George Herbert Walker Bush was president between 89 and 93, and that's when the resources were committed. And President Bush was outraged, and FIREA was enacted, and I became a FIREA prosecutor, and there was public outrage, and something was done about it, and it was a remarkable effort in terms of the success. Now, one difference, we didn't talk about this today, I was thinking about this though, one difference between the current crisis, the mortgage meltdown, is the actors, the criminal actors that were involved in the savings and loan crisis were not Wall Street elites. They were not nationwide Wall Street elites. They might have been elites in their hometown, but these were people from Texas and New Mexico and California. So they had clout. Everybody knows about Keating's efforts.
The Keating Five.
The Keating
yes.
Five. But it's not at all the same as the group of, I won't say criminal actors, but the group of actors that were involved in this particular crisis.
So maybe the hope is that we have to start decentralizing our crime wave a little bit in the hopes that it gets prosecuted.
Well, I think one thing you need to do is, and I've talked about this a lot, you need to create an atmosphere in both the regulatory world and the criminal prosecution world where you send the word out that we're not going to tolerate, this sounds very simplistic and easy, but whenever we find out, if we're a regulatory body, whenever we find out that somebody has lied to us, it's real simple. You can find it out, they find it out all the time. Whenever we find out that an institution we're regulating lied to us, that goes immediately to the top of the line. That immediately becomes a criminal referral. Think about Bernie Madoff. We all know about the absolutely atrocious job that the SEC warned about 5 times about Bernie Madoff. And astonishingly, in one of those times when they were investigating him, they determined that he had lied to them about whether or not he was an investment advisory service. And they did virtually nothing about it. They didn't do a criminal referral about it. That should never happen. One of the real problems in prosecuting financial fraud, it's great for me on the defense side, is, I hinted at this earlier, if you're the defendant and you can show, well, wait a minute, the examiners knew about this, the bank examiners knew about it, the regulators knew about it, it becomes much more difficult to prosecute that person. And it made it difficult in the S&L prosecutions. I had many cases I did where the people said, the defendants said, we told the examiners. The examiners didn't seem to care too much about it. Some examiner making $15,000 a year who's not paying a lot of attention on a particular day. But one thing that you can drill down, I think, to the lowliest examiner and the lowliest regulator is an absolute no tolerance policy if you find any evidence of lying to the examiner any evidence of a false document, anything like that, it's required. It goes into a different track. It goes into a criminal referral. If you would spread that ethos in the culture of regulation, you would have, I think, a very beneficial effect, and any party can do that.
A great bit of advice for the Department of Justice. Sol Weisenberg, thanks very much for spending the time with me this afternoon.
Yeah, it was great fun.
Yeah, thanks a lot.